NACDL is the association of the nation's criminal defense bar.
So when I first found out that I was going to be talking about searches of homes, I was sitting at the conference room table in our office, the lunchroom talk with the attorneys in the office, and I said, I got to think of a title for this presentation. And everybody immediately went to "A man's home is his castle," and I said, I feel like everybody knows that one. What's the modern day equivalent of the phrase "a man's home is his castle"? And one of the younger lawyers said, "Where the magic happens." And I said, what are you talking about? And he was telling me that on the show MTV Cribs, which is, for those of you who haven't seen it, it's kind of like a lifestyles of the rich and famous for the MTV generation. And they go into rock stars and celebrities' homes and they tour their houses. Whenever they get to the bedroom and open the bedroom door, the rock star says, "This is where the magic happens." And I started thinking about that, and we were laughing about it, but thinking about it really is the modern day equivalent of the term "a man's home is his castle," right? Because within our house is the most private space we know. It's a place where most of our secrets reside. It's a place where we have the biggest privacy interest. And within our home itself, probably the most private space is our bedroom. And whether it's "a man's home is his castle" or "where the magic happens," we can see throughout history, for hundreds of years, the concept that our home is the most sacrosanct place in our lives. And I love this quote from State versus Kylo: "In the home, all details are intimate details." Now, back in the days when we had castles, the way into a castle, the way into your home, was really over the walls or forcing down the door. And the people doing that were angry mobs with pitchforks and catapults climbing over the castle walls. Well, as we all know from the practice that we're engaged in, there is a new enemy at the gates. And although they are armed with guns and they are armed with tasers, flash grenades, and all sorts of devices, I would argue to you today that their most powerful weapon, the most powerful weapon that law enforcement has to get into your home is this. Because an officer needs probable cause to get into your house. And whether it's the probable cause that they define when they swear out a warrant and raise their hand in front of a judge and say, "Yes, officer, it's true," or whether it's coming into a courtroom and testifying under oath that one of these exceptions to the warrant requirement applies and gets them through your front door. It's really their credibility that we're assailing when officers come to court. Now, when we look at the definition of probable cause to enter the home, probable cause, it looks fancy, right? Facts and circumstances within the officer's knowledge with the reasonable belief of a prudent person, right? It sounds hyper-technical. But when we look at the way that the case law has interpreted this, it becomes, I guess, more simple and more complicated. Courts have called probable cause common sense. It's flexible. It's a case-by-case determination. It's the basis of knowledge and veracity being relevant, but let's not get too rigid with it, right? At the end of the day, this probable cause determination that we're asking courts to make comes down to the credibility of the person making the assertion, the credibility of the police officer. And if probable cause is common sense, and making a credibility determination is common sense is making a credibility determination, then probable cause is credibility. So I want to start today with a little bit of a different premise, or maybe taking a little bit of a different approach than some of the other presenters have been taking, and that is to say to you that it's not really a problem of law, it's a problem of fact. And perhaps this slide could be a little bit different, because I'm not suggesting that we shouldn't be pushing hard to change some of these laws and to make headway where we can. But I practice in a trial court, and for me, once a ruling has come down about the law, I'm kind of stuck with that until people smarter than me in the appellate court figure out a way to change it. But what I can do is make better factual arguments and make better arguments about the credibility of the police officers to try to get the judge to say, but not in this case, right? We're going to suppress the evidence in this case because these cases don't apply. So before we talk about searches of houses, and I promise we're going to talk a lot about searches of houses, I want to start by talking about articulating the facts of these cases more clearly to judges. Then we're going to talk a little bit about defining what it means to be at home. We'll talk about the impact of some of the new technologies that get officers from outside your house inside without ever having to cross the threshold of your door. We'll explore some of the common justifications for warrantless searches, some of the common justifications for searches with warrants, and then I want to discuss with you and show you maybe some ideas about credibility building when you're making your arguments both in written form and making oral arguments to the judge. So, getting back to this idea of an officer kind of coming into court and swearing to tell the truth, either before a judge making a decision on a warrant or a judge in a courtroom deciding an evidentiary motion to suppress. We obviously face an uphill battle when we're attacking officer credibility. And some of the reason for that are the reasons that Bridget Krause suggested to you yesterday morning, that judges are looking at all of their cases through their lens, which usually is not the same experiences with police that many of our clients have. But on the other end of that, we have another uphill battle. And that's this image of the police officer as a hero. The image of a police officer of somebody who is more likely to tell the truth than an ordinary citizen. And the issues that we're facing right now regarding police officers and the things that are going on in our country. And we're going against that whenever we put an officer on the stand and try to say to a judge, this officer's not telling you the truth. Judge, we're in DC. I'm sure many of you are familiar with Judge Michael Ryan. I had the privilege of hearing him speak about 6 months ago at a program in the Bronx. And he gave this fantastic presentation about making credibility arguments to judges. And he was kind enough to give me permission to use some of his slides today. And he said, we only get one shot at arguing credibility, but what we usually do is after we do a motion hearing, or when we come to court to do oral argument on a motion, is we kind of make the credibility arguments on the fly. And how many of you have heard yourself standing up in court and saying, Judge, the officer was inconsistent. The officer didn't seem to be telling the truth. His testimony didn't have the ring of truth. What does that mean? It kind of means absolutely nothing, but we really believe it when we say it. And it's true. But we're not doing a good enough job at making those credibility arguments sing, really making them mean something. And the result is that we lose control of the analysis. We don't give the judge a coherent framework in which he or she can assess credibility. And we wind up allowing the judge to fall back on everything we're trying so hard to fight against. His normal prejudice, his normal ideas of who police officers are and who our clients are, and his preconceived notions about how he should rule against us, right? So Judge Ryan suggested this very interesting framework. But every time we call a witness or every time we're assessing a case, that we take the players in that case and break them into 4 categories. And within those categories, start to record how we're going to make the argument when it comes time for us to do the oral argument on the motion. So for example, rather than saying the officer didn't seem to be telling the truth, if you're working within this framework, you would say, Judge, every time I asked him questions about what he did when he knocked on the door, he looked down. And I noted 5 times in my notes that he looked down when I asked him this, he asked him this. Or his voice softened, right? That's a better demeanor argument than he just didn't seem to be telling the truth. Same with inconsistency. Judge, he said a whole bunch of different things during the course of this motion hearing. Recording it, making a chart of all the inconsistencies made by the officer. It takes more time. It also takes you having to kind of start at the end and say, what arguments about credibility do I want to make to the judge? And how do I break down the chapters of my cross-examination of these witnesses in order to be able to credibly argue these things. So I want to kind of use that as a framework as we talk about the law of searches inside homes and start to think about ways that we can more vividly and creatively get at arguing credibility to the judges within the topic of searches of homes. So we should start by defining what a home actually is under our case law. And a home is a place where you have a privacy interest. That privacy interest is enjoyed by tenants, occupants of hotel rooms, occupants of a hotel room, even if that room was procured by some sort of fraudulent conduct, family members, overnight guests, guests with privileges, anyone who would have a reasonable expectation of privacy within the home. You're not considered at home if you've been evicted from a hotel room or evicted from a premises. Or if you're in a hotel room and you may cause such noise or damage that the police have to be called. So if you go out drinking with me and with Mike and with Deja and you decide to do a Mick Jagger in the 70s to your hotel room tonight, you're not going to be able to say, please, you can't come in and search my hotel room. Also, this applies to guests who have left, campers who don't have proper licenses to be on the property. So when we look at whether or not you are at home, what we're really looking at is do you have a reasonable expectation of privacy and do you have some sort of license to be there? So we have to look at whether you have an expectation, whether you're holding out an expectation of privacy in this place or whether you're kind of sending out the signals, hey, come on in. And there's a lot of things that we can look at beyond the evidence that we get in discovery to do that or to show that to the court. We should be looking into, in our investigations, arguing to the judge, ownership documents that tie the person to that resident, bills that may tie the person to that location, postal records, family photos, hundreds of photos of that person in the home, cell phone records, interviews with people who live in the home or around the home. And finally, front desk people and security guards. I don't think it'll surprise you, security guards know a lot of our clients, right? I've had many a case where I've tied a defendant to a particular location by interviewing the security guard at, say, a housing complex. They say, yeah, he's here all the time. He shows up at this time, he leaves at this time. Call that person as a witness. So we can look to sort of unusual sources to show that somebody has a connection to a particular piece of real estate or a particular room or location. Another question we have to answer about a home is once we decide that it is a home, is it exposed to the public or is it not exposed to the public? And this is where we get into conversations about whether or not something is connected to the premises or whether it's the curtilage of the premises. And there's 4 questions that we need to answer for the court in making this analysis. One is, how is the area used? How close is it to the house? Does the homeowner make attempts to protect it? Or does the area have some sort of enclosure? Is it enclosed in some way to keep it from the public view? And courts have defined this as the area to which normal life extends. Now, I'll tell you, when we put these presentations together, or when I put presentations together, I usually am scouring the internet for funny little pictures or things that might, amuse us as we're going through case law and going through all these principles. So I decided to Google strange things that go on the border of public and private property. And there's this website, this Google Earth website that takes pictures of like strange things on property lines. This was the first picture that popped up. I don't know who these guys are. I don't know what they're doing. I don't know why they're in Speedos. But I do know that they're on the line between public and private property. And if you were doing this analysis, you would have to analyze whether or not they're on the public-private property, whether in the curtilage, and whether this is the activity of normal life, and if it extends there. I don't know. What I did learn from this is don't Google that. There are some things, as the presentation before might have taught us, there are things you don't Google, right? Okay. So when you're arguing whether or not the property is exposed or kept private, one thing you have to do, and we can't say this enough, and I know Bridget said it a ton yesterday, you gotta go to the scene. You always have to go to the scene and look for things that would signal to members of the public that they are not welcome in this area. Signs are a great way to do it, right? A sign that says private property, no trespassing, violators will be shot, survivors will be shot again. That person doesn't want you trespassing on their property. You can also do video sketches and measurements of the area to show how close things are in proximity to one another. These are two similar signs that have very, very different meanings, right? Beware of dog has a very different meaning than beware of dog kisses, right? Somebody wants you on their property, the other person doesn't. A great way in court when you're doing the oral arguments on these types of motions is to use the Google Map application. I didn't want to attempt to get online while I was up here because it makes me nervous. But everybody's familiar with and has used this technology. I would encourage you to use it in court while you're doing the motion hearing on a case where a home was searched. If you want to show the curtilage, you can pull up the location, click it, and basically take the judge around the property virtually while you're sitting in the courtroom. Yeah. I have never had a problem doing it with a judge. Usually I can get the prosecutor to agree to let me use it or argue that the evidentiary rules are relaxed. I mean, I've never had a problem doing it, but technically. Using maps, getting schematic maps of areas to show the proximity of things is great. For housing complexes, this is a really great tool or technique that you can use to bring these arguments to life in front of the judge. And then taking the judge there, going on a view. In Massachusetts, when I practiced there, we used to do this all the time. We put the jury on a bus. We put the judge in the car. We take him to the scene. I came to New Jersey. I said, Judge, let's all go out to 187 Ellis Avenue in Irvington. And he said, wait, you want to put me in a car and take me to one of the heaviest drug areas in Irvington, New Jersey? I said, yeah. He's like, move on, right? So it may work in your jurisdiction, it may not, but it's a great way to show the judge what the home actually looks like. Technology is interesting, and I love, is Andrew Northrop still here? No, Andrew Northrop spoke yesterday about, he was the second person who spoke about cell site technology, and he doesn't know this, I was gonna announce this to them, but I'm like a little bit of a groupie, because when I hear him talk, and I've heard him talk before, he knows so much about the details of technology, and it amazes me, but he also frightens me. And the reason he frightens me is because he always says stuff like, yeah, can the phone do this? Yeah. Can the phone like burrow into your brain and put a chip there and record your dreams? I don't know, maybe, right? Like it's like he makes any weird technology thing sound possible. So, but technology is, you know, the next frontier. I mean, a police officer could stand now miles away and be able to get inside your home. Think about that. I mean, that's crazy. So technology is, this never gets old for me. Neither does the picture of him in front of like the mainframe computer. So it's sense-enhancing technology, things like heat sensors, canines. There's a body of cases with dogs being brought to homes to stand outside to sniff for drugs inside. And then all the technologies we've been taught, I'm not going to go into detail about any of these because we have been talking about them for the last 2 days, but binoculars, airplanes, helicopters, stingrays, drones. People have their own drones now, right? Where will that take us? So the analysis when we look at technology is really twofold, and the cases kind of come down on two lines. One is the technology commonly available to the public? Because if it is, the police are more likely going to be able to use it to get inside your home. Or two, would it require great lengths for the public to use it? And the cases sort of come down like this. Commonly available, things like binoculars, airplanes. Apparently helicopters are commonly available to the public. And stingrays, stingrays, and not so much. Telescopes used from a quarter mile away, audio equipment that aids hearing beyond the normal ear, thermal imaging, airplanes outside public spaces. Where the line seems to come down is if the technology is so intrusive that it sort of disrupts life on the premises or property, it's not going to do it. And if it's not commonly available, it's not going to do it. So we have to ask ourselves when we look at cases involving new technology, can you use it off the shelf? How much does it cost? Where are we? A use of a telescope in a rural town where it might be more common is different than a use of a telescope in a city. One fun thing, just a fun way to drive local police batty, is to send them a subpoena to come to court with their binoculars, with the manual for their binoculars, the last time the binoculars were serviced. And they come to court with just a pair of binoculars and they're like, I don't know, and then ask them all sorts of questions about that stuff. And then use the technology in the courtroom if you can. If an officer says that he looked into the home using binoculars, say put it on the settings. You ever like look at somebody else's binoculars? They're like, hey, look at this. And you look in it, and if you move an inch, the whole thing goes like that. We do that, have the judge look through the binoculars. It's crazy. So think about ways that you can use the technology in the courtroom to show that it's not as easy for this officer to do what he said that he did, or it's not as easy to use this technology as the police may make it sound. So even though we have all this technology available, still one of the ways that police get into our homes more often than not is knock and talk. Knocking on the door, asking the occupant if they can come inside, or asking someone to come outside. And in the vast majority of cases, at least the cases that I see, this is the way that officers are getting in absent a warrant. When an officer knocks on a door, that is a limited search, a limited encounter, and it should be limited to something that's not searching the house, and it's limited in scope to just a conversation at the doorway. The police officers don't have the authority to order somebody out of a house or a hotel room for the purpose of arresting them or for the purpose of conducting a search. So when you're considering this encounter, very similar to the encounter that Bridget was talking about yesterday, an encounter of two people on the street, think about that encounter of two people at a door, of a police officer knocking on the door and saying that they have some questions. And when you're painting that picture for the judge, we obviously want to paint a picture to the judge that that's an intimidating encounter that caused whatever action followed. So you need to consider tone of voice, the words spoken, the amount of knocks, when did they knock, the position of the officers, how many were there, how big were they? What did they have on? What were they wearing? What did the SOPs say? Were they wearing their body cams? All of these things are things that go into that analysis of sort of painting the picture. And I ask you, when you're looking at these cases and thinking about how to argue them, to also consider the point of view. So very often we consider the point of view that we're arguing from the point of view of the police officer at the door. Consider it the other way. What does your client see or your client's family member see when they're looking through the peephole and it's the police outside? What is that interaction or encounter like for them? And try as best as you can to articulate that in your written motions and in your oral arguments. And I'll give you an example. So if we look at this encounter, you could say, and you know, back up for a second, and try to think about telling this in the language of story. I think as trial lawyers, sometimes we turn off the storytelling when we're not doing the trial. And motions are such a phenomenal place to do storytelling because it's not often done. So it's more interesting to judges. So you could say in motion papers, the officer knocked on the door 3 times and announced their presence. And after several minutes, the occupant opened the door and asked them if there was a problem. That's the mental picture that that's giving. Or in your brief, you could write, the officers knocked on the doors and the windows with their fists. They screamed police, not once, not twice, but at least 3 times. When no one answered, they knocked again until several minutes later, Claire Johnson opened the door just enough to pop her head through and ask the officers, is there a problem? That's the mental picture that you want the court to see. And by using language, like thinking about the language that we use when we're trying cases and using that in motion hearings, we can paint those pictures that Bridget was talking about yesterday morning. So plain view. So plain view, obviously we know what we need for plain view. And this is another area that I think we see a lot of police officers trying to get into our clients' homes. We all know that plain view alone doesn't do it. Just because an officer sees something, they have to be lawfully in the location from which they're making the plain view. So a lot of times we see this intersection in these cases of plain view and exigency, right? An officer looks through the window, he's on the sidewalk, he sees something going on in the house and automatically now thinks that he has a way to get inside. But what the case law tells us very clearly is that, number one, the police have to be in a lawful vantage point. Number two, it has to be a felony or serious criminal activity for them to be able to go inside, and the police can't create the exigency, so they can't purposefully put themselves in a position to see what's going on inside, like knocking on the door for the purpose of getting somebody to open up so that they can see inside. So when we're arguing these cases, we want to visit the scene, stand in the exact same spot the officer did, document the angle, if the door was, document how far open the door goes with charts, diagrams, measurements, photographs, and pay close attention to the way this house operates. How does the door open? Does it open in or out? How do the windows, are there blinds? Is there dirt? It's like my cousin Vinny, right? These trees with all these leaves on them. Are there obstructions? Is there something that would have prevented this police officer? Would he have had to move something in order to see the things he claims that he saw? And don't forget all the senses. A lot of these cases come from the scent of marijuana. Like officers walk by a place and it smells like marijuana, and now they're trying to figure out how to get inside. So not only looking at what the officer could have seen, look at what the officer could realistically have smelled. Anything that he could have insulated him from noise that he might have heard, and the distance where the officer was in relation to the interior of the home. Destruction of contraband is another thing that we need to be wary of in these exigency cases. Just because the item can be easily destroyed is not enough. There has to be some suggestion that the person was going to destroy it. So here we have to paint a picture of the nature of the emergency, the time that it would have taken to obtain a warrant, a reasonable belief that these people were in fact going to destroy the contraband, a knowledge of police presence, and the ease with which the contraband can be destroyed. So the ease is really only one part of the analysis that we have to consider. And again, the mere fact that it can be destroyed is not enough. I can't say how many times I've seen prosecutors stand up and say, well, it's cocaine. Of course, they could have flushed it down the toilet. That's not enough. You have to show something else. So you need to paint this picture that there's no way that this contraband could have been destroyed. Other forms of exigency, fleeing felon and community caretaking. I'd say Bridget and I had a great debate about which fuck the police picture was better, the girl looking over her shoulder or the girl in the tutu. I personally am a fan of tutus, so I like this one. So these are two other areas. I'm not going to go into them in great detail. Fleeing felon and community caretaking exceptions are just other things that you need to be aware of when you're looking at these cases. There are other ways that the state may or the government may argue that they can get into your house. Okay, consent. This one's for you, DC people. Secret Service, we do not consent to our store being searched. It's not that there's anything illegal. We just employ several Colombian prostitutes and don't want to tempt you. It's a little old, but I still like it. Okay. So consent, I know David Ball spoke with you about consent yesterday, so I just want to kind of talk about consent strictly as it relates to getting inside a home or consent to search a home. Probable cause is not required. There are jurisdictional splits on whether reasonable suspicion is. In New Jersey, it does require reasonable suspicion before you can ask to search somebody's house, which is sweet. Sometimes I come to these things, I'm like, I'm happy I'm in New Jersey. Police can enter and search a residence with voluntary consent, but it can't be the product of police coercion. Who can give it? Somebody who owns the premises, is a roommate, a co-resident, is a girlfriend, somebody who stays at the property lot and has the implied authority to consent. Landlords, hotel owners can't consent to these kinds of searches. Supervisors can't consent to these kinds of searches. And the police may not search for evidence if a co-occupant consents and another refuses. So just because someone gives consent to come into the house doesn't mean that they have consent to search every room in the house. If somebody has a proprietary interest in the room in the house, the officer may not be able to get in there. So consider everything. Go to the scene and look at it. Had a case one time where his name was John, and there was a big sign that said, John's room, go away. on his door. We took pictures of it to show that it was there when the police searched the house, but we brought it into court. And as the officer was testifying, I was actually holding the sign, and so we were talking about the sign. So physically having the sign in the courtroom, I think, made a better visual impact to the judge, so they could see this sign on the door and what it meant in the context of the case when the roommate had given consent for the police to search. The scope is limited. It's limited. Consent to arrest doesn't give the police authority to search the residence for contraband. And consent to enter common areas does not give the police authority to enter closed areas that are ordinarily used from the defendant, like John's room. So factors to consider: was the consent freely and voluntarily given? Was somebody else in custody that they were using to pressure the defendant? Was there threats or coercion by the police? And whether the police were surrounding the house or deceiving the person who gave consent in any way. I wanted to show you, this is actually from a case that we litigated maybe like a year ago, myself and a couple of other lawyers. And what had happened in the case, it was actually a car stop first, but then they got consent to search these kids' hotel room. Not kids, they were 18, but kids. Hotel room. And the law clerk had switched, and we knew that this was a judge whose law clerk did everything. So we decided to do a PowerPoint presentation for our oral argument on the motion to suppress hearing. And it was an 80-slide PowerPoint presentation. It was a 2.5-hour PowerPoint presentation where our sole purpose was to destroy the credibility of the police officer, slide after slide. And I tell you that the judge was paying attention. I've never had a judge pay attention to me for 2.5 hours. Ever. The judge was paying attention to everything. He was interested in it. Every time the prosecutor objected, he would just be like, sit down, this is interesting. He was actually telling the prosecutor to sit down, it was interesting. And these were just some of the slides that dealt with the consent and the reasonableness issue. So timelines are a great way to show consent. The officer testified he was eager to get this over with quickly. And then we pointed to all the places where he had refused consent over time, and there was actually more of this. The officer's microphone, this is in our state, it's mandatory to record the taking of consent, and there's procedures if your microphone fails on your, the SOPs, it's not mandatory constitutionally, it's mandatory by police procedure that you record consent if you're wearing if you're equipped with a body mic. And there are procedures to follow if your mic fails. So we got the standard operating procedures. These are all taken from the PowerPoint presentation. The SOPs and the procedures to follow if you don't. And then we showed how the officer changed his story about the microphone. Because when we first started questioning him, he said he didn't mention that the microphone had failed because he hadn't seen the MVR yet. Then we said that we pointed out the flaw, and he said, well, it wasn't on me. It was in the car. And then over time, his story about why his microphone failed changed so many times until the very end when he was the hero. He said, it failed, but I had the presence of mind to go retrieve it after I got consent and didn't record it, right? And what we wanted to show the judge was not only was this officer lying about the consent, but that no matter what lie you pick, it was a violation of the procedures. So we did a flow chart, right? So if he says, the phone was in the charger, he didn't write a police report, that's a violation of the standard operating procedures. If he didn't turn it on, that's a violation of the operating procedures. If he knowingly, as he wanted to paint himself out to be, if he was the hero who suddenly remembered and then turned it on, he still didn't write a report, so he's violating the operating procedure. This is just a different way of showing the judge what you mean rather than just making the oral argument. And you're going to hear later today from Jubal Scott on the issue of race, and how to litigate motions where we suspect racial profiling, which is a real treat, and I can't wait to hear her. I've heard her speak before, and she's amazing. But race was a component of this case, so I just wanted to show you an example of how we tackled this. Because like I said, we needed to show that there was no reasonable suspicion for them to ask for consent. So we need to kind of say the whole initial stop was bogus. So we started with this idea that the police were following these defendants from one town to another, 3 18-year-old African-American kids, from one jurisdiction to another. For those of you who don't know New Jersey, Plainfield and South Plainfield Plainfield is a predominantly urban area. South Plainfield is suburbs. And they patrol that border like it was the border between the United States and Mexico. I mean, there are people lined up, officers lined up on the border, and it's a problem we've been having for a long time. So the police officer follows them from urban Plainfield to suburban South Plainfield for over a mile. No traffic violations, no crimes committed. And then he says, well, we were going the same place. Of course, when he was following them, how did he know where they were going? So this was the first slide. Then one of the items retrieved from their car was a softball bat. So we said there was no indication that these kids were wanted for anything, that there had been a robbery with a softball bat, and there's no description of suspects that matched them having anything to do with a robbery and a softball bat. And then there was this exchange on the MVR. Look what we have here, says Officer Williams. Yeah, like any of these people play softball, was the officer's response. Then the officer said this, which during the hearing made me want to pop out and punch him. I believe there was evidence of criminal activity taking place with 3 suspects out of the vehicle. That's enough for me to heighten my awareness of my surroundings. I mean, you know what's going on in the country today. So by going through these slides, that was when we said, Judge, I'll tell you what's going on in the country today. And we gave our little speech that this was a racial profiling stop. And the prosecutor jumped out of his chair. How dare you accuse this cop of being a racist? And the judge, who is the most wishy-washy, wimpy judge you can imagine, said, sit down, prosecutor. They've made a case for it, so they can say it. That's what I mean about credibility. It's easy to stand up in an oral argument and say, I think this was a racial profiling stop. But if you build the case and show the judge all the evidence before you draw the conclusion, a judge who is the least likely judge to have bought that argument at least was responding to it in a different way. So warrants. You know, you get a feeling when you open your file, like the world is new, right? Everything is good. A client walks into your office. The world is new. Anything is possible. And then you look through the file and you see the warrant. I don't know, there's a face I make. It's like this. That's my warrant face. Because when I see a warrant, I go, I have to write something. It's probably going to have a case cite in it. I don't get to cross-examine anybody. I'm bored. I had to write something, and now I'm just repeating myself. Right? It's like, there's a warrant. So I want to talk about some ways to at least try to maybe make our search warrant applications or our challenges, I'm not sure, our search warrant applications, we're not applying for them, make our search warrant motion applications a little bit more exciting. So particularity, we all know that a warrant must specify the place to be searched and the items to be seized. So when we're arguing, I like to call it pin the tail on the donkey when I get a search warrant and I'm going to make a challenge to particularity. What I started doing a long time ago is instead of going through the whole case and understanding the case before I go out to the scene of a warrant, is I take the warrant, I don't read anything else, and I go to the place, the area. And then I walk around and I say, would I know what to search if I was a police officer who had this warrant? You would be shocked at sometimes how hard it is. But if you wait until you know a lot about the case before you go there, it kind of ruins the game. And if you go there just completely blind and try to pin the tail on the warrant location, you can sometimes come up with some great legal arguments. This is not the actual one, but I litigated a motion a couple years ago. We had a server mishap a few years ago, and I lost some stuff. So this is one of the motions I lost. But I went to a place, and literally there were 2 doors that looked exactly the same. They had no numbers on them. And the officers went right. I don't know why. I don't know why they didn't pick the door on the left. They went right. So when I filed the motion, I put in a picture. And when I came to court, I was showing all these pictures of how you couldn't tell the difference between these 2 doors. And at some point, the prosecutor woke up and he said, hey, this isn't an evidentiary hearing. She's not allowed to show all these pictures. And I said, well, Judge, I lost the argument. I made some argument about why I should be able to. I lost. I said, but Judge, you're a judge. You know how to follow your own limiting instruction. So you can just pretend you didn't see that. And he said, oh yeah, I'm going to cross it out. I said, cross it out. He puts an X on the picture. Now, I don't know whether he could, you can't do that. If I were to describe a place to you right now, you might all have like slightly different takes on what that place looks like in your mind. But after I show you this picture and I describe it, you're all going to see the same thing because there are things we can't unsee. Right? So the scope of the warrant. This is another game I like to call the cat in the Pringles can. It's aw, right? It's cute, right? Okay, so when you're looking at the scope of the warrant, you got to ask yourself 4 questions. 4? I'm doing this, 4. What are you looking for? Is that reasonable? Where is it likely to be found? And where did they find it, right? So what are you looking for? I'm looking for a cat. Is that reasonable? Let's pretend in the context of our case, it's reasonable, all right? I'm looking for a cat. It's reasonable to be looking for a cat. Where is he likely to be found? Not in a Pringles can. Now, I recognize the inherent flaw in this slide is that the cat is, in fact, in the Pringles can. But I argue to you 2 things. 1, that doesn't matter, right? It really doesn't matter. What matters is where is it likely to be found? And number 2, if the internet has taught us anything, it's that if there's a choice between logic and a cat in a Pringles can, the cat in the Pringles can is going to win. So, but consider that. Consider where the item is likely to be found. Some other issues to consider with the warrant, the use of confidential informants. The reason I didn't focus on that in this presentation is because it's very different from jurisdiction to jurisdiction. And it's also, I think, it's fair. The law is fairly clear. It's just how you apply the facts to the law again. Staleness, did the warrant go stale? Did the probable cause of the warrant go stale? And then Frank's hearings, which are uncommon. Cool if you get them. I've never actually successfully gotten a Frank's hearing, but I've tried like heck to get them. And remembering that for a Frank's hearing, a deliberate falsehood or a material disregard for the truth, and the defendant is required to present a preliminary proffer of material falsehood. So I wanted to just put it all together for you and show you one more sort of sample. And this is from a written motion. Case where it was a hotel room search. The police had gotten a tip, and trust me when I tell you the tip did not justify probable cause, and nobody pretended it did. They knock on the hotel room door. My client looks out the window, looks out the blinds, closes the blinds, and says, "The fucking cops are outside." Some noise, like little noise, like people walking around. The police officers keep knocking, banging on the door. Finally, the co-defendant comes to the door, opens the door, and then the police officer starts telling him about this tip that he got, orders both defendants out of the apartment, keeps them there for 9 minutes until the drug guy comes. And while they're keeping him there, he's propping the door open with his foot. And we had learned that it was a door that automatically slams closed. There's no way to hold it open unless you're holding it open with a body part. The officer said he was holding it open. He sees chore boy on the table, which is, of course, evidence of crack cocaine, some chore boy, and then they go into the apartment, do a protective sweep, and arrest both of them, take them outside, then take them back into the apartment to take their confession, back into the hotel room to take their confession. So lots of moving parts in this case. There's about 9 places that a judge could stop this police conduct, right? So there was a question of where to begin. Like, there was going to be about a 30-page written motion, and I know no judge is going to read 3 pages, let alone 30. So I was like, where do I begin? How do we get the judge on our side right away? Not chronologically, right? Because that's boring. My suggestion is when you're doing these written motions, is to start with either your best legal argument or to start at the portion of the stop where everything changes, where it takes a turn to negative town for our clients, right? As Justice Kennedy said, I've never read a brief that I could put down. Try to at least get the judge to read the brief for as long as possible. And where to begin creatively? I suggest you start thinking about it like an opening statement. A quote from the discovery, the best quote of the case, a description of event or scene, paint a really vivid picture of a scene, or the biggest bone of contention you have with the state's brief. I try to avoid a case quote, like a case citation, unless it's really, really, really good and really, really, really on point. So in this motion, there was a lot of talk about where to start, like how to how to get the judge to be interested in what was happening with our client. And you do have to know the judge. The particular judge that we were in front of for this motion was one that's very responsive to emotional arguments. I had watched the previous motion she had done, and there was a guy on the MVR who didn't have a coat on, and nobody was arguing he was particularly cold, but she just kept saying, where's his coat? He doesn't have a coat. I'm like, oh, she's a softie. So I got to try to find a way to pull at that. Different from Simon Cowell, right? He's a mean judge. He doesn't care if you have a coat or not. So this is how we chose to start. I say we because I had some young, like super smart lawyer in the office helping me with this. This is how we chose to start the fact section. 9 minutes. For 9 minutes, Sergeant Abrams and Patrolman Jackson of the Anytown Police stood outside room 209 of the Red Roof Inn. Defendants Brian and Leonard, the occupants, were with them. They were forced to stand outside with armed and uniformed officers, forced to wait for Detective Carullo. During those 9 minutes, Abrams used his feet and hands to keep the door of room 209 propped open wide, giving him a clear view of the interior. During those 9 minutes, Abrams let the opportunity to call for a telephonic warrant pass him by. During those 9 minutes, the officers didn't hear as much as a whisper coming from room 209. The events that led up to this moment neither justify ordering the occupants of room 209 to exit their home for the night, the hotel room, nor do they justify entry into room 209. That one paragraph fact section essentially hits every single legal argument we were going to make in the next 30 pages. And I hoped is in an interesting way. There's sort of a catchy introduction. The theory of the motion is contained in there. There's a trilogy. There's intentional use of the passive voice to show that these defendants had no control over what the officers were doing to them. And there's like word pictures we were trying to create the scene in the judge's mind. And there's a copy of this brief in your. The other thing was the state's argument was that the officer was propping open the door. When he saw the chore boy, he could go inside to arrest them for a disorderly person's offense of possession of drug paraphernalia, which is so not even remotely close to the law. Like all you have to do is read Coolidge versus New Hampshire, the case that we had talked about when we talked about plain view, to know that they can't do that. And when I read her brief, I literally went like this. Huh? So this is how the legal section of the brief started. That's a quote from the prosecutor's brief. It's the most messed up interpretation of the law that I've ever, not that I've ever seen, right now I'm being dramatic, but it was messed up. And I wanted the judge to be like, why is that crooked? So if that's on her desk, why did she make something crooked, right? So you read it, and then you read the next paragraph underneath it, and it's like the prosecutor's whole premise is wrong. So we won the motion, and the state filed a motion to reconsider, relying on one case. And when I read the case, I said, wow, this case is really good for me. It's helpful. I can't believe I missed it the first time. Right? It's a really good case. And I had made a chart in my office of the two cases, my case and the case, this State versus Jerez, this New Jersey case. And then I wrote like a 15-page brief. And the young, smart lawyer from my office comes in, and he's like, oh, I like your chart. And I said, yeah, I'm working on this brief. It's like 15 pages. I'm trying to narrow it down. And he goes, that chart's better than your brief. I was like, oh my God, he's right. So this was our response to the motion for reconsideration. A paragraph that said, this is the case. This is our case. I think a law clerk, anybody here who's been a law clerk, I think would appreciate that a lot more than my 15-page nonsense, right? So I'm trying to at least encourage you to think of sort of more creative ways to capture the judge's attention, more creative ways to talk about these searches and to visually bring them to life, particularly when it's a search of a house where sometimes we feel a little stuck because we don't get as many opportunities to do evidentiary hearings, and we don't get as many opportunities to always do like longer presentations or oral argument. All right, so in conclusion, know the legal theory of suppression, know the story, try to think about how you're going to argue credibility at the end so that you can build the chapters into your cross-examination to allow you to more credibly make those arguments. Investigate thoroughly, investigate outside the box, and try to chapter your cross to really call the details that are going to support those conclusions if you do get across. And use visual aids to bring the key points to life. I think I have a couple of minutes. So I do want to, before I sit down, just say something. I was debating whether or not I should say this, but I'm going to say it because I have a couple minutes. I wanted to see how much time I had. I was, for some reason lately, I don't know why, I've been thinking a lot about what it means to be a woman and what it means to be a woman working in the criminal justice system. I have no idea why that would happen. And it is so inspiring and encouraging to me to see how many women are here. And when I've gone to these conferences over the years, I see more and more of you. And men, I love you. That could come out wrong, but I love you. And I am not in any way undermining or disparaging any of your contributions to the criminal justice system, and you're all amazing, and I work with so many amazing men. But it really is in this time amazing to me to see so many women here. I met with a woman that I met here, I don't see her in the audience, from Texas, who was telling me that she's getting paid less for death penalty cases than some of her male counterparts because they can set the system that way, and she's fighting the cases rather than rolling over. So they're paying her less per hour. 2 weeks ago, I was with a woman in Missouri who for 25 years did death penalty work in rural Missouri. And we got into a conversation about her struggles and her journey as a woman doing that kind of work. The Bronx Defenders, I see some Bronx Defenders in the house here. They're waving. They just opened an office in Tulsa, Oklahoma, where more women are being arrested per capita than any other city in the United States. And when I think about this work and I think about my relationship with NACTL, it's all of my heroes in this business have been women. Deja Vishny, who is the chair of this conference, who's an amazing lecturer and speaker and teacher on confession and suppression, who just wrote this phenomenal book, Suppressing Criminal Evidence, that's not just for people who want to sit around and intellectually think about motions to suppress, but for a brand new lawyer or anybody in their career, they can pick it up and they can walk into court and feel 100 times more confident about trying a case. Or Colette DeVette, who popped in, and she's the head of the Indigent Defense Committee here at NACTL. And Lois DiGiulio, who's not here, but is heavily involved in suppression issues in New Jersey and was the first female DAG in New Jersey. And I've been so fortunate to have all of these women in my life, and they're the reason that I've been brought here today. And I just want to thank them so much for this opportunity, to thank NACTL, and to thank all of you. Well, men too, you're back in now. All of you for coming here and for sharing all of your stories and for all of us to be able to put our heads together and do this kind of thing. So thank you.